Welcome to Civil Procedure, Subject Matter Jurisdiction. In this video, we will discuss federal question jurisdiction, the bookends of Osborn and Motley. While state courts can, and often do, hear cases that arise under federal law, the federal courts themselves serve a distinct and indispensable role. That unique role is to safeguard the uniformity, predictability, and supremacy of federal law across all jurisdictions. Without this consistency, the same federal statute could be interpreted in one way in one state and in a completely different way in another state, undermining the very principle of national coherence. If the federal courts exist to ensure the uniformity and supremacy of federal law, the next question is, where does that authority actually come from? In other words, what gives a federal court the power to hear a case simply because it, quote unquote, arises under federal law? We discussed this in a bit more detail in video 1 of this series, in the introduction to subject matter jurisdiction. But to make sure that we're keeping this in context, we're going to revisit the doctrinal framework of federal question jurisdiction. And in order to do that, we must distinguish between two distinct but closely related sources of authority. I refer to these as the two bookends of federal question jurisdiction. That's the constitutional bookend, which is represented by the Osborn case, defining the outer limit of federal judicial power under Article 3, Section 2. And at the opposite end of the scope, we have the congressional bookend, which is represented by the Louisville and Nashville Railroad Company versus Motley, which interprets Congress's grant of jurisdiction under 28 U.S.C. 1331. Together, these two cases represent the two bookends that form the structural boundaries of arising under jurisdiction. One establishing the full constitutional scope, that's Osborn, and the other one delineating Congress's much more narrow statutory grant of arising under. That's the Louisville case. The constitutional foundation, the first authority for federal question jurisdiction, begins with Article 3, Section 2 of the United States Constitution. Again, if you watched the first video in this series, you've seen this slide. This is where federal courts are granted their judicial power. Specifically, if you look at the green highlighted portion of this slide, you will see that the federal court is granted judicial power to adjudicate all cases in law and equity arising under this Constitution and the laws of the United States and treaties made or which shall be made under their authority. This clause, the arising under clause, is the constitutional foundation. The constitutional foundation. In other words, this constitutional clause represents the outer boundary of federal judicial power under or rising under. This is the maximum reach that the Constitution permits, all cases. It defines what is constitutionally possible. It does not establish what is actually statutorily authorized. What is actually authorized by congressional enactment is the opposite end of the spectrum. It is the opposite bookend. That is represented by 28 USC 1331, where the Constitution defines the outer boundary, right? The maximum reach. 28 USC 1331 defines what Congress says federal courts can actually adjudicate under the arising under clause. Today, a federal court may exercise federal question jurisdiction only when the federal issue appears on the face of the plaintiff's well-pled complaint. On the face of the plaintiff's well-pled complaint. This is the doctrine that is refined through the Louisville and Nashville Railroad v. Motley case. So, modern rule follows the congressional limitation that is identified in 28 USC 1331. But we're going to introduce this from the broad perspective of Osborn. And as we did with personal jurisdiction, we're going to watch through the application of case law, the evolution of federal question jurisdiction. Before we move on, I want to acknowledge this statute appears simple. It's deceptive. It is not in the observable simplicity where the power sits in the statute. It's in the interpretation of the doctrine that is this statute, right? This simple looking sentence holds the well-pled complaint rule. That silence was intentional. The intent was for you to take in the hugeness of simplicity. Simplicity isn't easy. It's actually very complex. That brings us to a perfect discussion question. Maybe in your study group, or maybe if you're just thinking through this process. Understanding that we have three co-equal branches of government, understanding that that equality is safeguarded through the checks and the balances that the branches exercise between themselves. If we have a Congress who has, in fact, pursuant their constitutional authority, decided to create lower federal courts, why would that same Congress want to limit their reach? Why would Congress want to limit what those federal courts can adjudicate under any jurisdiction, but for this case specifically, federal question jurisdiction? Think about it. I'm sure you can come up with some really interesting talking points. Let's get back to it. Let's see how the contrast between the broad constitutional standard and the more narrow congressional standard of federal question jurisdiction actually plays out when it's applied to real people, real cases, real conflict. We'll begin with Osborn v. Bank of the United States. That's an 1824 case where Chief Justice John Marshall articulates the full constitutional possibility of arising under. Then we'll turn to the Louisville and Nashville Railroad Company versus Motley case. That's out of 1908, where the court recognized that it's Congress that determines the limit of what the federal courts can actually adjudicate out of all of the possibility. It is Congress that actually decides what of that possibility will be exercised. In video 4, we will move to Grable and Sons Metal Products versus Daru Engineering. That's a 2005 case where we will see how federal question jurisdiction operates when the federal question is embedded in a state law claim. And then finally, in video 5, we will explore Gunn v. Minton. That's a 2013 case, which defines the modern limits of arising under jurisdiction when a federal issue appears inside of what is otherwise a state law cause of action. Together, these cases trace the evolution of federal question jurisdiction from its constitutional breadth to its present, carefully calibrated statutory scope. Before we review the Osborn case, we want to position ourselves for maximum understanding. Let us recall the political and constitutional atmosphere of the early republic. This was an era of intense struggle over the scope of federal power and the legitimacy of a national bank. Okay, 1776, independence from Great Britain. That's where the colonies declared independence and began the difficult experiment of self-government. 1781, we have the Articles of Confederation, which were our first national charter, right? This is our first governing document. This was before the Constitution. Unfortunately, or maybe fortunately, the Articles of Confederation proved themselves to be too weak. It left our new nation unable to tax, unable to regulate commerce, unable to enforce federal law, unable to offer any national defense. 1787 to 1789, we have the United States Constitution being debated and then born. The framers replaced the Articles of Confederation with a much stronger structure of federal power. So understand what I'm saying. There's a more structurally sound, more authority holding federal government, right? National government. Get it? Right. Federal courts, state courts, the conflict between federalism, all started in the beginning. The relationship between federal government and state government has been a difficult one since the beginning of our republic. This is not new. Moving on. 1819, we get the McCulloch versus Maryland case. In that case, Chief Justice John Marshall upheld Congress's authority to create a national bank and struck down Maryland's tax, right? That famously declared the power to tax involves the power to destroy. So, what do we have happening in March of 1819? We have the Supreme Court handing down a specific, clear, direct statement about Congress's ability to create a national bank and the limited ability of a state court to stand in opposition to it. State court, Maryland, had a taxing system that was going to tax the federal bank. United States Supreme Court in March of 1819 said no. This is what makes this profession so amazing. Amazing. At the time that the Supreme Court is issuing a holding that strikes down the Maryland's tax scheme against the federal bank, you have Ohio now, 1819, becoming the epicenter of continued state resistance against the U.S. federal government, right, as focused on the national bank. Just because the court said it once doesn't mean that the fight's really over. State leaders in Ohio viewed the second bank of the United States that sat in Ohio as an illegitimate federal intrusion and vowed specifically to defy McCulloch's ruling. This defiance would soon lead to a direct clash yet again between state sovereignty and federal authority, which is going to culminate in the Osborn v. Bank of the United States case. Right? You've got McCulloch holding 1819. You've got Ohio establishing a very similar taxing regimen against the federal bank, right? Same year, 1819. And you've got what is the Osborn case, where a holding wasn't actually given until 1824, but the event started in 1819. This is the best drama, right? This is what our rule of law stands for. This is what encompasses the essence of being able to argue and participate in a profession that is focused specifically on the rule of law. Okay. February 8, 1819, the Ohio legislature enacted a statute that imposed a $50,000 annual tax on each branch of the federally chartered second bank of the United States. If you are a naturally curious person, you might ask yourself, well, if this is the second bank, of the United States. What happened to the first Bank of the United States? It failed, but we're moving on. The law that was enacted February 8, 1819, required that if the tax was unpaid by September the 1, the state auditor should issue a warrant and could, quote unquote, send any person or persons to collect the funds. So every year there's an annual tax, $50,000. If by September 1 of that year, that tax has not been paid, then on September 15, the auditor is authorized to issue a warrant and send a person or persons to go get it. Well, the bank refused to pay. The bank maintained that the tax was unconstitutional under the recently decided McCulloch case. On September the 14th, 1819, the bank leadership filed suit in federal circuit court against Auditor Ralph Osborn and other state officers seeking an injunction to prevent enforcement of their state taxing law. Early September 15, the federally issued injunction was served on all necessary state officials, but the state officials ignored it. Oh my goodness. Can you feel the excitement growing? They ignored the injunction. The state officials ignored the injunction that was issued by the federal court. On September the 17th, 1819, acting on Osborn's orders, Osborn is the state auditor, state treasurer John Harper, and a team of hired agents, check this out, referred to as the Rough Riders. Yeah, this is amazing. Yeah, stormed the bank's branch and forcibly removed $98,000 in cash. $98,000. That's 1819 money. $98,000. In today's money, that's nearly $3 million. They took it by violence and they were off with it. The state of Ohio argued that the federal court lacked subject matter jurisdiction. So they're saying what? That the injunction was not a valid order. Oh my gosh, did we just come full circle from video 1 where all we're trying to get is a valid order? That's our personal jurisdiction, our subject matter jurisdiction, our notice, our service, our venue. We just need an enforceable order. It's got to be a valid order. And the state of Ohio is saying we ignored it because it's not valid. Federal court has no jurisdiction over this, no subject matter jurisdiction. This is a state tax enforcement action, not a case arising under federal law. The stage is set. With that, the stage is set. Oh my goodness, right? Gotta go watch this movie. This is a good one. Issues. As you have studied over the last few weeks, almost every case has more than one issue, right? You might be studying a torts case and see that there's a civil procedure issue, but your professor may not address the civil procedure issue because it's a torts class, or vice versa, or a family law issue, or a constitutional issue, right? And depending upon what doctrine you're studying, where your professor will focus on the issue that's associated with that particular doctrine. So it's not new to us that this case is going to have lots of issues. Yeah. But the four issues that are identified, what makes this case so different is the court is actually going to address all four of these issues because each one of them alone is extremely necessary to be resolved. Our Constitution is roughly about 30 years old in 1819. We are still trying to figure out what systems do we have in place? How are they going to work? If they're going to work, what do we do if they do work? What do we do if they don't work? So a lot of this is still, we are trying to figure this out. Okay. So four issue statements. Under Article 3, Section 2 of the United States Constitution, does a case, quote unquote, arise under federal law when a federal issue forms an ingredient of the cause of action, even if that ingredient is not independently dispositive of the claim. That's the issue question that we're focused on. That's number 3. That's what we're focused on. But it's worthy to address the other issues. Issue number 1, does Congress have constitutional authority to even create the Bank of the United States? All right? Because if Congress has overstepped their authority in the creation of this bank, the rest of this is moot. Remember the justiciability doctrines? The rest of this is moot. We don't need to address it, right? Justice Marshall reaffirmed McCulloch versus Maryland and held that Congress had implied power under the necessary and proper clause to charter the bank. That's issue 1. That's how it's resolved. What's issue 2? Does Congress have authority to confer on federal courts jurisdiction over all cases involving the bank? Over all cases involving the bank? What is that addressing? That's addressing that in the charter of the second bank, Congress specifically states that the bank has the power to sue and the bank has the power to be sued in federal court, right? And this is what happened, or this is one of the reasons the first bank of the U.S. failed, is because that language to establish jurisdiction under the federal courts wasn't there. And as a result, that meant that state courts could issue all of these different rulings against the national bank, and there was no way for the national bank to survive that. So one of the things that Congress made sure that they did intentionally, specifically, clearly, without doubt, right, was to include in the second bank's charter the ability to sue and be sued in the federal court. And so the question is, does Congress even have the authority to do that, right? Does Congress even have the authority to do that? The third issue, that's the one that we are addressing. I already stated it, arising under. The fourth issue was the injunction that was issued by the lower court. That was the initial injunction against the state leadership, right, to enjoin them from taking action in the collection of this tax. Was that injunction properly issued, right? And the underlying dispute, whether the state officers could tax and seize the funds from the bank, was also addressed. 4 issues for our purposes, where we're looking at subject matter jurisdiction. What does arise under mean? We're really focused on issue number 3. Okay. All right. So to do what we've been doing, we've got a 3-point issue statement. What is the rule of law under Article 3, Section 2 of the United States Constitution? That's where we're going to get this resolved. What's the legal question? Does a case arise under federal law? Does a case arise under federal law when? When a federal issue forms an ingredient of the cause of action. Yeah? Do we have arising under if the federal issue is an ingredient of the cause, even if the federal issue is not independently dispositive? So that is the issue statement that we will use for this case. My fact, element, analysis, outcome map. My fact, element, analysis, outcome map. You know, I like charts, I like tables, I like maps. I like when I can actually walk through and see how the court is analyzing, what the court is using to analyze. Because if I'm given a essay exam, I'm being asked to do the exact same thing, right? So let's just take one. You will have the video, so you will have the chart, and you can do it at your leisure. And maybe charting doesn't help your process, then don't do it. But find out whatever it is your process is so that you can be consistent, so that you can be methodical, and so that you don't miss anything in your analysis. So here we go. Ohio imposed a $50,000 tax on each branch of the federally chartered second bank of the United States. Well, why do we care? Well, we care because there is a branch of the bank in Ohio. Ohio doesn't want the bank in Ohio. And Ohio said, if the bank is going to be here, then we're going to tax you, right? When the bank refused to pay, another fact, Auditor Ralph Osborn ordered the state agents to seize $98,000 in cash. Okay. What is the element that I'm looking at? I'm looking at the federal instrumentality. How is federal law? How is Constitution? How is treatise, right? All of those things that are under my arising under clause in Article 3, Section 2, how does that connect? Well, it connects because the bank is congressionally created. The Congress is a federal, right, institution. It's a branch of federal government. The Congress, the federal government, Congress, instituted via a congressional charter a bank. See how see the touches that the federal government, the Constitution, right? Because the Congress is acting based upon constitutional authority. What constitutional authority? The necessary and proper clause. That's constitutional authority. So the fact that we've got this bank as a outcome, all is connected from the Constitution giving authority to the Congress exercising that authority to create the bank. Get it? It's all connected, right? And so, what's the court's analysis as to that fact and that federal instrumentality? The bank was a lawful instrumentality of the federal government. Marshall reaffirmed McCulloch v. Maryland. Congress may adopt means necessary and proper to execute enumerated powers such as taxation, borrowing, and regulating commerce. So, what is the outcome? The bank's federal origin anchors the case within the federal constitutional power. Ding, ding, ding. And then we've got number 2 and number 3 and number 4. You might have different facts. Hopefully you have these facts, though, because these are going to be some of those facts that are going to be able to anchor you in the doctrine of the Constitution, be able to anchor you within the doctrine of the Constitution. Well, we've already isolated our issue for the purposes of subject matter jurisdiction, specifically federal question jurisdiction, right? So let's revisit the question, just posed a little bit differently. Does this case arise under federal law for purposes of Article 3? Chief Justice Marshall began with the constitutional text itself. Justice Marshall said Article 3, Section 2 grants the federal judiciary power over all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made under their authority. This central question, therefore, was whether the dispute, a suit by a federally chartered bank of the United States seeking to stop state officials from seizing its funds under the Ohio state tax law, could be said to arise under. It's critical to remember that the court is not interpreting 28 USC 1331. We're talking about 1819 through 1824 to get this case resolved. 1331 did not exist. We are still trying to identify what these judicial powers are. We know what the words say, but when the words get applied, what does it mean? Right? Instead, the court was defining the constitutional outer limit of federal judicial power. Right? The court was trying to determine how far Article 3 actually allows federal jurisdiction to reach. This is the foundational moment for the doctrine of constitutional arising under. Constitutional arising under. Having identified the constitutional question, Justice Marshall turned to his answer, which is what we know now to be the ingredient theory of arising under. Marshall reasoned that a case arises under federal law whenever a federal issue forms an essential part, whenever the federal issue forms an ingredient of the plaintiff's cause of action. In Osborn, the bank's claim plainly rested on federal authority. We've said it already, we'll say it again. The bank was chartered by Congress, a federal branch under federal law, that's the Constitution. Its charter authorized the bank to sue and be sued in federal court. It relied on McCullough v. Maryland, which was just recently an issued holding to claim immunity from state taxation. In fact, to claim that state taxation on the bank was actually unconstitutional. And it invoked the Supremacy Clause to invalidate the Ohio statute. The Supremacy Clause. Oh, we love it. It made its debut. Justice Marshall held that these federal elements were sufficient to satisfy Article 3, Section 2, even if the immediate controversy resembled a state law dispute, right? The underlying right that was being enforced was a federal right. Thus, the court defined arising under jurisdiction not by the surface form of the pleading, but by the federal substance that's embedded in the case. Well, let's look at our holdings. We're going to go ahead and look at all four, okay? Chief Justice Marshall resolved the four key issues this way. As to the issue regarding whether or not Congress had the power to create the bank, the holding, Congress possessed constitutional authority to charter the bank under the necessary and proper clause. Check. That was a check mark. Issue 2, congressional power to confer jurisdiction, holding, Congress validly authorized federal courts to hear all cases involving the bank through the sue and be sued clause of its charter, because the bank derived its existence and powers from federal law. Any case involving it necessarily invoked a federal source of right. Issue number 3, ours. This is ours. The arising under issue. Holding. A case arising under federal law when a federal issue forms an essential ingredient of the cause of action. The court held that the bank's claim satisfied Article 3 jurisdiction because the bank was federally created. It relied on federal immunity recognized in McCullough, and it sought protection under the Supremacy Clause. And then issue number 4, proprietary of the injunction, holding. The federal court properly enjoined the state officials. The suit was not barred by sovereign immunity because it was directed at individuals acting beyond constitutional authority, not at the state of Ohio itself. The injunction and the restitution of funds were a lawful exercise of federal judicial power. What is the rule of law that we walk away with from Osborn? Under Article 3, Section 2 of the United States Constitution, a case arises under federal law when a federal issue forms any necessary part or ingredient of the plaintiff's cause of action, even if the federal issue is not dispositive. The constitutional test, the constitutional footprint, the constitutional reach of arising under is very broad. Why are we considering a case from 1819? After resolving the doctrinal questions, Chief Justice Marshall stepped back to emphasize what this case is really about. And what this case was really about in 1819 is still important in 2025. Justice Marshall stated, "The institutional role of federal courts," he explained, "is to guarantee the supremacy and uniformity of federal law across the nation. If Congress creates a national institution like the Bank of the United States, and if Congress authorizes it to operate nationwide, then that institution must be protected from hostile or inconsistent state interference. And that protection must come from the federal judiciary. If the power to interpret and enforce federal law were left solely to state courts, particularly when the state itself is a party to the dispute, federal supremacy," said Justice Marshall, "would be at risk." This is what Marshall wrote: "The judicial power of the Union is competent to the decision of every question arising under the Constitution or the laws of the United States, and the state courts cannot be depended upon to maintain the paramount authority of the federal government." This reasoning echoed McCulloch v. Maryland. States may not obstruct. States may not obstruct federal function. The federal courts stand as necessary guardians of the constitutional balance, ensuring that federal law remains supreme, uniform, and effective throughout the nation. That is still important in 2025. In closing, Chief Justice Marshall drew a distinction that remains foundational in federal jurisdiction today. Article 3 defines the full constitutional scope of federal courts, the full constitutional scope of what federal courts may hear. This is the outer boundary of judicial power. This is the maximum reach of judicial power. Okay. We know that Congress, however, determines what cases federal courts can actually hear from that wide berth of possibility. Congress decides how much of that potential power to confer through statute. And Osborn, the court was interpreting only the constitutional reach. Only the constitutional reach. Now, the Osborn holding planted the seeds for what came later, which was the statutory narrowing of that broad, wide breadth of power, right? Osborn planted the seeds for Motley. So in effect, Osborn defines the ceiling, the outer reach, where Motley is going to define the floor. That balance between judicial power and congressional control continues to shape the boundaries of federal question jurisdiction to this day. In conclusion, Osborn v. Bank of the United States stands as the high watermark of constitutional federal question jurisdiction. It established that so long as a federal law plays a meaningful role, that's that ingredient, in the claim, a case falls within the arising under clause of Article 3. even if that role does not qualify in a more narrow structure of the grant of judicial authority. So Osborn is always going to represent the constitutional ceiling, right? The potential outer maximum reach. And that is the Osborn case. Yeah, fantastic. So with Osborn giving us the outer limits, our next video is going to cover Louisville and Nashville Railroad Company versus Motley. And that's the other hand, right? That's the other bookend where it's going to show within those outer limits, what exactly is Congress going to authorize the federal courts to actually adjudicate? Got it? Of course you do. So exciting. Looking forward to seeing you in the next video when we look at the more narrow, congressionally limited exercise of the arising under jurisdiction for federal courts.